moderating a panel on managing risk, DRM, the policies and procedures, and all those nice things, technologies that actually make that stuff work. I am, unlike what it says in the panel, I recently did a job with a company called Citric and Company that does risk, does crisis communication. So basically, when all these guys, when the DRM doesn't work, they call me up to help make it look better. But I'm going to start out by having these fine gentlemen each introduce themselves briefly and talk a little bit about their specific gig, and then we're going to get into it. Filippo, why don't you start?
Good morning, everybody. My name is Filippo Luise Brandi. I work with KPMG. KPMG Contract Compliance Services. Contract Compliance Services is a division of KPMG. Is focused on verified compliance of licensors and licenses. And I've been working this business for the last 10 years. In the last 3 years, I focused my attention on the digital marketplace. So I perform a royalty examination on behalf of the content owners and content creators, auditing a mobile carrier and other third party which are entitled to report royalty to my clients.
Good morning, everyone. My name is Trent Larson. I'm with a company called Protiviti, and you may ask who's Protiviti. Well, Protiviti was formed by a group of ex-Arthur Andersen partners for the risk management, risk advisory side. So our history is very deep in risk advisory and consulting services. My role with Protiviti is I lead the digital media practice. So I enter into a lot of things that obviously IP is going to be one of them, content protection. And then we do a lot of work around what we call revenue assurance. So wherever there is content that's sold, there's a transaction that takes place, and there's likely to be, at least in legitimate cases, there's a revenue that's triggered. So we help manage that, make sure that that's properly tracked. If there's a royalty or a partner settlement split that's supposed to take place on that, we help ensure that is properly tracked. Now, my background, I spent about the last 10 years in the European market with IBM, IBM's digital media team, where a lot of the activity was around mobile entertainment as well. And also in a previous life, I had the good fortune of working with my colleague on the right, on my right here, Filippo. So I think we'll have a pretty good conversation, discussion here with all things related to IP.
We should be good on at least 2 continents now with your all's experience, so that's good.
My name is George Borkowski.
George, could you speak into your microphone?
I head up the intellectual property practice at Mitchell Silverberg and Napa Law Firm here, based in Los Angeles. I have throughout represented both content owners, such as the record industry, record companies, the motion picture industry, and others, as well as technology companies, including Apple and Wingo Wireless, Signal Wireless, and several others. So I kind of approach these debates both from the content and the technology side. Primarily, I enforce intellectual property rights. I go after people who violate the rights of content owners and the rights of technology companies. And I get involved in a lot of circumvention and anti-circumvention analysis, not all of which is public. A lot of it is my clients approaching me and saying somebody else out there is doing the following, or is trying to circumvent this or that. Is it illegal? Can we do something about it? I also give advice on rights management to many clients as well. I started in the area by representing the record industry in the Napster litigation, and have done the major record industry P2P cases afterwards as well.
Good morning, my name is Reza Rasool from Whitevine Technologies. My position is Chief Engineer. I've been with Whitevine since its inception, early part of this century, during the Heady.com days.
Are we in the Heady.com days again?
I think we're in probably more realistic, more pragmatic, more jaded era than those days. But our company's mission is to provide a comprehensive content protection for content owners. Its products include encryption, conditional access products, but the product family that I'm in charge of is an area of digital forensics, including watermarking and fingerprinting. In the early part of the company's business, I ran an anti-piracy service for the studios. It was a service way ahead of its time and provided the evidence that was used in the Grokster MGM Kazaa case.
As a former MGM employee, I thank you for that.
You're welcome.
MGM versus Grokster was one of our highest.
Somebody litigated that case, I think.
And
Yes.
it'd be wonderful if the studios were prepared to pay for such a service.
Oh, they paid, believe me, I saw the bills, so.
But it's put me in a sort of a position of a dilemma. I'm an engineer that is working to protect the rights of content owners, but I'm also a user of content. And I'm also a father of 4 boys who want to
Really use content.
really use content. And so the perspective that I have is a mixed one. And it's a continuous cause of internal conflict for me, and hope we can use this forum to help rationalize some of that.
I think that's actually a nice jumping off spot for the first question, which is, you know, the RIAA once again just filed another 8,000 lawsuits in 17 countries against illegal file sharers. I was involved with, when I was at MGM, with the MPAA's decision to get involved in cases against file sharers, and obviously participated somewhat on the Grokster case. Let's do an assessment. I'd just be kind of curious about a 50,000 foot level from you guys, given your all's involvement in this space. How does that work? I mean, it's paid a lot of bills for a lot of lawyers and a lot of other technology folks, but how has that approach, I'll start first with the RIAA, and I think the MPAA in their defense has done a very different approach. It's been certainly less expensive and perhaps less annoying to the general consumer. Give me a sense of what you all think about it. And let's start with the attorney.
Well, one thing, it wasn't the RIAA who filed those suits, it was IFPI.
You're right, I'm sorry.
Trade organization in Europe.
It's the overseas equivalent, that's right.
Which it is, but they're not actually
Technically the same guys, you're right.
They all can work together. Our firm actually was the firm that here in the U.S. filed the original program,
Right.
started the original program for
Right.
user enforcement. And you asked whether it works. You know, it obviously is something that is highly controversial. My sense is if it didn't have an impact, the people in Europe wouldn't be doing it because you don't want to have to go after your own consumers unless you feel that that's a need. The way we've always looked at it is one component of a much broader strategy that has to involve, first of all, business models. You can't have business models when people are stealing your content. It has to involve market forces, it has to involve education, it has to involve several other things. So I think it is effective to some extent. It will not be effective in a vacuum, and it is expensive. The difference in the MPAA motion picture approach and the record industry approach isn't so much a difference because they didn't like what the record industry was doing. It was that the technology they were going after was different at that point. It's essentially BitTorrent sites, which run very differently. And so it's a lot, you're not really going after your average user who may happen to have 100 songs on his or her CD, hard drive. You're going after sites that are aggregators of the bits that actually lead you to where all various files are located.
The pointer servers are really gone.
That's right. So these people are integrally involved in the process. And they're not the grandmother that you sue inadvertently. They're people who it's hard to make a plausible argument that they're engaged in something that isn't overtly unlawful.
Right. And the tracker servers, I think, is actually the term, right, for the BitTorrent
Yes.
area. But basically, they're the central computers, much like in the original Napster case, that point you to where all the good stuff is. Trent, what do you think about it from a slightly different standpoint?
Well, I think in this latest one, my understanding is there were a lot of individuals that were brought up in charges as well. And on the international scene, there was over 2,300 that were already voluntarily ready to pay the fine just to
Make it go away.
to make it go away. But long term, is it going to work? It's hard to say. If I use some other analogies, speeding fines don't stop people from speeding. We still do it.
They pay for the course, though.
Pardon me?
They do pay for the course, though, the speeding
Well,
fine.
they do pay for the course, and they perhaps help improve some of the roads. But I think what will happen is it will be something that society is going to have to embrace the fact that. In fact, no. Let me take a step back because I don't want to take one side or the other of this. I think that society is going to have to determine what is legal and what's not legal. And now I know my colleague to the left of me, on the legal side, is going to say, well, obviously this is stealing, which I would share his opinion on that. But I've spoken at many universities, and I speak at high schools and everything. And every university that I go to, I have a student, at least one, that'll come up to me and say, "How can you call this piracy?"
That's the fast one, is it first?
And they say, how can you call this piracy? There's no theft. This is a product that was already out there. By my downloading of it, you're not having to create another copy of this. You're creating another physical product. And so there's an awareness issue. And take this one step further. Reza, far in here, just made a comment about his family, his sons. That they all want to consume music. And the interesting thing, you look at parents with young children, and I have a 7 and 8-year-old. If I ever caught them stealing a candy bar, a 99-cent candy bar, from a high street shop or a grocery store, they would be in serious trouble. But that's not always the case. I talk with other parents who say the same thing. If my child stole anything from a store, they'd be in serious trouble. But they don't necessarily have the same view of downloading a piece of content, perhaps worth the same value. So why is that?
Well, and that certainly does speak to one of the challenges when I was at MGM. One of the challenges we faced was, as George was saying, trying to create a multi-pronged approach that does involve, not just enforcement, but education and all these things. DRM, actually, the reason I want to hear kind of from you, because you've given your multiple areas of touch points on this issue, right? I'd like to hear your
So, obviously technology can be applied to solving this problem, but it's a multifaceted problem, and you can address the problem either by prevention or by cure. And if we just follow the money trail, you can see that lots of people whose vested interest is in pursuing the cure route and curative measures, and who get reimbursed by efforts that are in the camp of curing, and then there are others that get reimbursed by preventative measures. When as a technologist, I'm looking at new technology and how can it be applied to this whole domain of content protection, I'm trying to look at it in an ethical and a long-term view that might transcend the shorter-term monetary motives of not only my company but my immediate customers, because I think that we're not solving a problem of content protection, we're solving a problem of market creation. And a market is a two-way street. We're not preserving just the interests of the content owner. We also have an obligation to protect the rights of the consumer. So if we turn this whole question on its end and start looking at it from the consumer's point of view, and we start looking at the issue, and the title of this session is to do with risk management. So we're looking at what is the risk from the content owner's point of view, and ad nauseum, we've been sitting through panels where talking heads are talking about the position from the content owner's point of view. The position from the user's point of view is, I buy a piece of content and it gets a scratch on it, and I can't use it again. I've got stacks of DVDs that I can't play anymore. I've got content that I've downloaded that I can no longer play anymore. I've got media, but we're told that we've acquired the rights to it. I would certainly pay to have those rights, to purchase those rights, to be assured that should I want to download that content on a new device that's yet to be produced, I would be allowed to do that. I'd certainly pay for that. The challenge for engineers is to come up with technologies that help address the problem from both angles. In the case of not of educating users that this content actually is of physical value, and they have a responsibility in the ownership of it. We've addressed that through forensic technologies, through watermarking. It's a two-pronged approach. It's not only tagging the content to say that David Bloom downloaded this content, purchased this content on this particular day. It also notifies you and makes you aware that this content is in fact traceable back to you, either through a visible bug that comes on the screen or an introduction.
Well, the NSA knows where it is anyway. So.
The NSA. You know, it depends if you're really creating these technologies as a cure or if you're creating them as a preventative measure. If it's as a cure, then it's going to make the lawyers rich. If it's a preventative measure, chances are you'll stem the problem before it needs to be cured.
Yes, what you mean? What do you see different between prevention and cure? I don't think.
Okay, so during the period when the Mensa service ran, we were tracking through a peer-to-peer crawler system. We were tracking thousands and thousands of downloads of content, and we populated a huge database of content of these instances of downloads, right down to the IP address and the time of the file size. We also had fingerprint technology that could do a recognition, an automated recognition of the content with respect to the files, the original content that we were contracted to protect. And so we had this database, and we also had an automated way of generating DMCA complaints. This service we ran for 2 years for the studios. In addition to that, we could take that further and do a cluster analysis and a strain analysis and find out that, you know, out of these 3,000 different instances of teenagers serving up content, they actually originated from 3 original thefts. So now the attorneys were presented with the case of, hey, I could send out 3 DMCA letters and get $50 a time for it, or I could focus my efforts on going after these 3 original thefts. And we were continually, at least in those early days, encouraged not to focus on those 3 original thefts, but focus on providing these large lists of instances of individual piracy.
So one of the things the IFPI lawsuits also beg a sort of related question to some of what we're talking about here, in that when you're trying to swing across 17 countries, you have 17 sets of rules, 17 sets of what's okay, more or less. Certainly the Scandinavians have shown, and the French have shown some interesting opinions about DRM, some of the moves that have been going on there. I'm curious, and particularly our European fellows here, you're now officially half a European, and Filippo has the name and the accent to do it. I'm curious about if you all could talk a bit about how it may change when you're trying to comply with contracts, how it may change what you do when you go to do business in Europe. You take your content from the United States, you know what DMCA is, you know what's legal here, what's not legal here, more or less, and you go to Europe and you try to do business there and sell your content. What are you going to face? How are you going to deal with it? You want to start, Filippo?
Well, from an audit standpoint, when you have an agreement with an American company, and based on this agreement, you can have your content distributed in Europe, you have to be sure that the entity, the partner that you are closing this deal knows how are the regulation in Europe, and they have to comply with such regulation. I mean, that's not an option. Europe is changing, is going to a direction of create one rules. So, but it will be probably not in the near future.
Right.
So it would be important to be sure that your partner has in place a system that complies with the terms of the agreement. Even if it's distributing the product in France, where, for example, the accounting system is completely different.
Shocking. And we'll take questions at the end. If we could just write down your hand and wave your hand later.
But when you're also talking about Europe, I mean, there is the EU copyright initiative.
Right.
They are trying to standardize.
They're trying. They are.
Basic copyright
Right,
protections,
right.
which you know, I think the problems, the fights are less about, you know, how extensively copyright attaches as to issues of kind of fair use and circumvention.
Right.
That's where the interoperability, and that's more what the fight is rather
Right.
than the basic principles. So that's
Right.
the whole.
But they're not there yet on the EU country. I mean, Europe-wide rules still aren't fully in place. I mean, I hear what you're saying, but even there, you still got spots
Right.
that are going to create a headache. And obviously, as you said, accounting systems are different and everything else.
I think when there's a lack of consensus, then there's more of a likelihood that there could be imposed regulation. It could be in the form of levies or taxes and that sort of thing to help compensate. But you know, I think what you've pointed out is there is perhaps a greater level of fragmentation when you have a series of closely related but you know, in many ways culturally different populations. Now, we're fortunate in the you know, in the American or North American market, a fairly substantial population base that all operates under one regulation. And the European market doesn't particularly have that luxury. And I was just looking at some of the statistics in the French market, for example, for music consumption. 80% of music in France is local tongue native artists, so 20% is international. So they have a different set of issues and requirements than perhaps, you know, a larger population base such as North America that has a larger English-speaking or English content. And then, of course, you've got Germany, Italy, where they're about 70% local content. So we're trying to establish worldwide interoperability and worldwide policies on fair use, or what we believe is fair use perhaps on this side of the Atlantic. It doesn't necessarily fit their definition of fair use. I think that's why we see France and some of these organizations attempting to go off on their own to establish different rules that would govern the use of content and copying.
Speaking of Europeans with a flexible view of American copyright law, John Lech Johansen, who's known as DVD John in his previous incarnation, has come to the United States to make his fortune. He, as his first blow, has reverse engineered the Fairplay DRM for Apple and is now hoping to sell it to other companies so that their content can run on iPods. Kind of curious about what you guys think about that approach, whether you think that that is going to dodge DMCA, and what you I'm just sort of curious about your predictions about what Steve Jobs thinks about that. Who wants to take that first?
Well, I'll start because I'm going to leave the legal part to my colleague here. But I think in terms of the business side of it, obviously Apple makes substantial revenue on their device.
They don't make it on the music though.
Yeah.
I mean, their margin on the music it actually may be negative.
Yeah,
So the numbers I've seen.
So maybe from Apple's perspective, I'm not speaking on their behalf, maybe from their perspective, they're going to say, you know what, if we can have more content that plays on our device, we can sell more devices, and maybe that's a good thing. You know, all legalese aside.
Okay. What's the engineer thing?
Well, quite cheekily at IBC, Widevine showed on their stand an iPod running where the content did not come from an iTunes store. and we actually developed a system where the Wi-Fi encryption could be used instead of Fairplay, and it showed that there is an alternative. Without actually hacking or reverse engineering, there is an alternative to getting your content to that population of devices. In Europe, certainly, it received a lot of attention. We haven't got the attorney's letters yet from Apple, but
What did your attorney say? 'Cause I'm sure you all have a couple of them too.
we got, I wouldn't say it's, our own on-staff attorney said it was okay. I'm not sure if you're aware of how the Apple, how music's in fact secured. It's secured by their encryption during the download, but then it's decrypted and then re-encrypted locally. In fact, in the initial version, it was actually transmitted in the clear to your computer and then encrypted locally before it was ingested into the internal store. So it turns out that was a big, that was the first hack, was trapping it there. So these well, one thing, it exposed that maybe the security solution there wasn't so much to secure the content, but to preserve the business model, was to preserve their hold on your having to not only buy the device but get the music from their source. But I think you're absolutely right. I think it makes more sense for them to have more content there and to have other content owners want to target their platform as the playing device. It's not really essential for the content to be hosted by them.
George, what do you think?
I think about three different things, especially since they do represent Apple and had this discussion with them. The way you have, I mean, if they thought, if they would prefer, if they thought there was advantage and they'd be doing it now, there's nothing that prevents them from making the iPod.
They could have thrown it open in France and didn't have to.
That's right. I mean, their view on it is that they present an entire integrated user. This is their approach. They present a completely integrated user experience. You always know what you're getting. You know the content is secure. You know it'll play a particular way. You know it can be organized in a particular way. And, you know, that's what they're selling. They're selling this integrated experience. You know, my sense is that Apple is a company that is amazingly resilient to market forces, as you've seen just by the iPod. But I think that at some point they feel it's to their advantage, and they can allow that to happen. You know, it's a decision that they're going to make at the upper echelons over there.
Certainly, a wink and a nod approach can also work without actually embracing something.
Well, it's I mean, you know, I know D. John is saying he's come out with this thing that kind of circumvents fair play, but there have been programs out there floating around for about 2 or 3 years.
Rhapsody, I think, did it.
No, even before Real did what it did, there were just in the hacking community, there have been programs out there that can do this to some extent. So I'm not sure what he did necessarily that's all that different, except maybe he did it better.
He's got better PR too.
Probably does. But the selling of it, you know, if you do it here, I mean, it's likely, and I haven't been asked to analyze this, because, you know, this DVD junking just came up, but, you know, it's likely trafficking an anti-circumvention device, which is...
Well, that's what I was worried.
DMCA.
DMCA is like you're just like
Mostly.
fighting a problem with
Yeah.
DMCA, and then you can't hide like in Scandinavia.
Yeah, but I guess it kind of will depend on how this code works, you know, whether it truly circumvents, whether it does something else. And,
Right.
you know, until that question is answered, then nobody really knows what the options are, I think.
Okay. Apple, the mention of Apple brings up just a sort of a general question. What does work? What technologies out there are working? I mean, I might argue that the only DRM out there that's really sustaining a market right now is the fair play. I mean, in terms of a substantial money-making operation. If you guys could each from your various perspectives kind of speak to that, and Filippo, why don't you start? I mean, what have you seen in the compliance work you've done, the work that you've done? What out there seems to be working now in both the market way, in providing reasonable access to content, and protecting that content? What comes to mind? Anything besides Apple?
Well, when we talk about contract compliance and in the digital marketplace, when we are talking about how the content owner protect their IP, which kind of control they have on the sales of their product, how much they can rely on the content aggregators or the distributors. But this is the key question nowadays. I mean, which kind of control do they have? And I don't want to talk about Apple, of course. I think that it would be fair now to make any name or speaking specifically on a specific company. But
There's nobody here, it's okay.
well, but you know,
And I'm
from
taking
an artist
that.
standpoint, I have an artist that he put a lot of time, a lot of resource in his content, and he made a deal with this publishing company, and he get the royalty, he get his royalty statements. And how can he verify that the revenue that is being reported is complete? We are talking about anti-piracy, we are talking about security. I think that the very first step to control and to check that your IP is actually in a good hands is to perform a royalty audit of your partner. I don't want to say audit, I would like to say an assessment, because audit is still a term that,
Sounds like the IRS as opposed to the friendly guys over at KPMG, right? Yeah.
And one of the biggest challenges nowadays is, and I want to talk to the attorney now, which kind of power do they have to do this control? Because in a traditional market, you perform the audit, you go to the distributor, you check their books, and you verify the sales, and you see the royalty base and what you reported. But in the digital marketplace, we have so many entities in the value chains. So many partners that report each other in a very different standard data format. So how is it possible to perform this kind of work through the line? And which kind of language the audit clause should have to allow the content owner to perform such control? In my experience, sometimes we start the audit and we don't have access to the raw data.
Okay, so you're saying there's not a way for folks who are trying to make sure that the money that they're owed gets it. There's not a standard way to even keep track of these systems and how they're generating income for people. Is that?
That's correct.
Okay.
So is there any, from an attorney standpoint, you think that there is a change in the language of the audit clause that can allow the content owner to keep track of the sales, to keep track of the sales of his product pending on the audit? Do you think that?
I don't do a lot of water work. I'm really not familiar with those audit clauses that much. Other than I'm not necessarily sure why a digital format would create any additional issues on royalty reporting than anything else does. I mean, for example, the owner of the sound recording, whether it's the record company, which it usually is, or somebody else, it has to keep track of all the revenues that it takes in and gives out from all sorts of secondary and tertiary sources. So I'm not sure why just having a couple of other sources to keep track of makes things any different, other than might add a couple more revenue lines. There's also, for terms of digital public performance, there is the sound exchange, which is being created now to keep track of music that's subject to Section 106.6 of the Copyright Act, which is a digital public performance, which is essentially streaming or something similar to that. So there is another body of data.
You mentioned Sound Exchange. I'm sorry if I break in, but this is Sound Exchange is the entity that should collect this revenue and distribute to the artist.
Right. Is this a? I'm not familiar with Sound Exchange, and maybe some of our audience members aren't either, though they're probably much smarter than I am. Sound Exchange is was it a government setup?
No, it's essentially, it initially was set up in collaboration with the RIAA, but It's now separate from the RIAA. It's an organization that keeps track of performance, digital public performance royalty for digital content.
But only digital content
Yes.
through
Yes.
all the different.
Well, actually, on the radio, only non-subscription.
All terrestrial
Yes.
broadcast and all that.
So it's all.
It's only for the radio on internet.
That's correct.
Oh,
No, it's digital public performance, meaning it has to be, because there's no public performance right at terrestrial radio for the sound recording. So yes, it's.
so when a radio signal is sent out over the internet, they're keeping track of all that.
That's
and
right.
Who gets paid, just as somebody's keeping track in the publishing houses and all
That's
that
right.
for play on over the airwaves.
That's right.
Okay. Trent, Rezi, you want to talk a little about what's working out there?
What's working?
And what's making money for people, protecting content, not annoying owners too much, buyers too much?
Nice. Yeah, the solutions that work are ones that accept the reality that they're going to be broken. So solutions that have renewability over cost of revocation or renew of the security solution where that cost is minimized, that is a solution that works. You just have to look at the various websites, let's say the Microsoft website, and look at the timetable of the patches to fix security patches, and you can see the instances of how frequently a security solution gets broken. There's a huge force out there, collective force, working to break security solutions. So any security solution that sets out as the cure-all is setting itself up for a rude awakening.
So just to sum, what works is something that's pretty good, but is easy to fix.
Is easy to fix, easy to renew. So if your security solution's enshrined in, for instance, a smart card, your smart card gets hacked. You've got millions of smart cards to send out again. It's extremely expensive. The opportunity we have with digital transmission, with IP transmission, is you've got a two-way connection to the client. There's all that opportunity now to use that to renew the security solution now at the client. Try and keep your smarts as much up at the server end. Other aspects are ones where you can actually identify the location of the leak in your security solution, so you're not compelled to renew the entire population of devices. So it's basically systems that accept the reality that it's going to be broken.
Trent?
Yeah, I think that raises a good point, because no system is going to be bulletproof. But also, we've talked about Apple iTunes a couple of times here, and is that working because the DRM system used on there? Is it working and being so successful in spite of the DRM? I think that
That's exactly the point I wanted to make.
Well, and
My point is, I think Apple's successful with the consumer. That success is not based on DRM.
Yeah,
It's not directly, it's indirectly based on it, so the content owners wouldn't give
well,
Apple.
that's my point is you wouldn't get the content, which helps
Right.
the whole ecology of the
Yeah,
iPod.
consumers like the experience of the iPod and iTunes.
Yeah,
That's
I
why
mean,
it's-
the content owners are relatively okay, though obviously most of the studios haven't put their movies up yet. Most content owners are relatively okay, and the Beatles haven't put their music up.
Metallica has that.
Metallica broke. They finally broke. That's true. They finally came over. Madonna came over. A few other big names, but there's still Led Zeppelin isn't on there either, I believe. I just want to know what they're thinking, because it's not like people aren't trading the Beatles and Led Zeppelin online for free. You might as well get a few dollars out of it. Anyway, you're right about Apple probably succeeding despite its DRM, at least with the consumer, and succeeding with the consumer because the labels can live with it. Now, recently, on the eve of the Google YouTube deal, YouTube announced arrangements with several labels, and I think a couple of studios to do the thing that does not involve DRM, to basically split the advertising revenues on content that is illegally uploaded onto their network. And this is a kind of a different approach, basically. This is sort of the realist approach, saying we'll be partners. We'll be essentially your rebroadcast partner on here, and we'll do a deal that gives you a chunk of our company, so you can make $50 million, and help you have a piece of the revenues we make off of this. Is this the alternative going forward that makes sense, or is DRM still what needs to be there?
I think they're trying to cover both bases on that. They're trying to capture a market that will be more likely to consume content if it is, supposedly free, and they're not going to give up on iTunes, so that they're trying to go both ways. And interesting, when you start looking at it from a user perspective, I would rather pay money to have exactly what I want when I want it, and free doesn't necessarily mean a better service or a better offering to me.
So they have better quality in many cases.
Yes. So I'm looking for perhaps a better user experience. And I know there's a lot of people that view it that way. Other people, because perhaps they have more time on their hands or various reasons, would happily be, I wouldn't say inundated, but happily view ads in order to support that. And I think one of the models that's coming out now that I believe has good potential is the option to view ads before purchasing or consuming content. Mm-hmm. And that model would be whereby you're about to download the content, whether it's audio or video, and there'll be a little file folder next to it. And say, for example, if the content is worth $2.50 for the content, you can open this file folder, there may be 5 ads in there. Each ad, if you view that ad, that reduces the price of the content by 50 cents. So obviously, if you go through all the ads, you get the content for free. But it has a requirement of your time to just sit there and view that. So that kind of covers both sides of it, and I think that can address,
That's a pretty explicit transaction that probably consumers haven't been used to making in the past. It's interesting that would come out there. It seems like it would have some opportunities. The technology could make that happen. What do you think, Reason?
Yeah, technology could make it happen. As a user, I guess I'd welcome the ability to choose having ads or not having ads, and I'd be prepared to pay a difference in price.
As a fabulously well-compensated engineer, you would, but your time is scarce, you'd probably want to just buy it and look at it. Your children, however, because you don't give them an allowance, might want to go ahead and spend that time.
I guess so. Or I might choose to allow them to watch the cheaper service.
Oh, what father would do that? Now, I'm sort of curious in general. This sort of broader question is: do we need DRM? We have some things that are evolving. Do we have to have DRM? Has it worked? Has it done stuff? Just in the biggest possible way. Has it done its job?
Well, it's worked I think importantly in one sense, or maybe 2 senses. The realistic goal behind DRM isn't that you're going to make something that's hack-proof. That the hacking community isn't going to be able to get into. What you're doing is you're trying to keep your average user honest, and you're trying to make it difficult for your average, online user or your average person who goes out and buys a DVD at Best Buy or something. That they can't easily circumvent it because, and that is the bulk of your buying public. I mean, most people aren't going to be sitting out there trying to hack DVDs or try to get past protections to get either music or other content. I mean, that's true maybe for certain age groups if they have a little bit of time, but it's not really your user base. To the extent you have decent DRM that prevents everything just being out there in the clear, I think it's succeeded to a significant extent just on those grounds alone. And the second part is the Apple part, and the content owners aren't going to require it. I mean, that's just a reality. So you need decent DRM, you need DRM that's easy to fix, like you said, so you don't have the smart card problem.
Right.
You need to keep the bulk of the people honest, and the ones who are truly egregious, you go after and you enforce.
Right.
And I think that is, it's a little simple, but I think that is a model that has been followed and is going to continue to be followed.
Okay. What sort of policies, and we've kind of talked about some of this. Filippo, could you talk a bit about what needs to be done to help make this evolving world of content acquisition pay off? It seems to me that we have some challenges ahead of us in terms of figuring this all out. I mean, are people like you going to get, is this like a full employment act, for instance, the YouTube deal, is this a full employment act to make sure that the revenues that Warner Music has got coming actually show up? I mean, are you guys just going to be sitting in YouTube's offices all year long with a counter? Or how's that going to, I mean, just from a practical standpoint, how's this stuff going to work in terms of actually divvying up the money that may be coming in?
Well, and, I mean, the U2, I mean, I don't think that they give up all the rights for this deal.
Right.
I think that the key would be to define in the agreement which kind of product can be delivered, which kind of territory, in which format. So define exactly on what the royalty should be paid.
So it's really a full lawyer employment act, is that right? So MSK is going to be doing very well, it sounds like.
And also to see also which kind of revenue. I heard about this formula to put advertising and content together. Is the content owner then entitled to the revenue from this advertising? And how we can keep track of this revenue? Is the advertising on an internet website? It's the revenue driven by these by the advertising. Is keep track only from the website owner. They have to give us access to all the views and their revenue. So from an audit standpoint, it's not just have the logs of the delivery of the product. We have also to get access to the general ledger of the company, see the amount of revenue that they generate, how many sales you develop selling my music track. How many companies, how many banners you sold. So we need to have access to the counters and to the delivery logs. It's a challenge from an audit standpoint.
So there's this huge infrastructure that's going to be created to kind of keep track of all this stuff. That's the next step in the evolution of Web 2.0, it sounds like, is the really unglamorous stuff about who's getting what. Is that accurate?
Yeah, I think there's going to have to be a little bit more thought given to how this is all tracked. I mean, if we use the example of the optional advertising, how do we know that the person has fully viewed that? Maybe it's an interactive ad where it's,
Click on this at the end.
click on this or answer this question, or maybe, I don't know. So that will introduce complexity, but it just depends whether that's viewed as a viable trade-off for no compensation or untracked compensation.
Right. One of the, I had a conversation with a fellow a couple days ago. I just lost my train of thought, which is really terrible here in the Switch House. About DMCA. And his point was that the Digital Millennium Copyright Act is, 8 years old, 9 years old now, and it is already woefully outdated. I would be just curious, because some of the things we've talked about today, what you guys think. Are there changes that you guys, from each of your all's perspectives, that you think need to be included in the next DMCA? And what would you like to see? Who wants to take that?
To be attorney.
It's an easy question.
Well, I'll agree with you that it's, out of date. I mean, the joke was that the DMCA was passed and that a year later, after it came out, you kind of look at it, it's like, where's this coming?
Yeah, that was a date. It was out of date about.
It was on
months
the
later.
moment it was enacted, essentially.
The ink was still damp.
The part of it, there's actually two components to it, I think. There's the there's the anti-circumvention provisions of which I don't think are out of date. And I think a lot of countries in Europe and Australia are thinking of adopting portions of that if they haven't already. It's the other part of it, it's the Section 512 part that you're talking about that deals with internet service providers and what an ISP is.
Safe harbor
And
provisions.
all the safe harbor provisions and all of that. And I think that to answer your question, I have to answer it generally. I think it needs to take into account the kind of social networking sites that we're seeing exploding everywhere, because those really are, I mean, you could say they're covered by certain provisions.
Right.
And they probably are very literally, but
That's a lot of law stuff
but
before you
the
figure
full,
that out.
but the full spirit behind how these sites operate isn't really covered under
Sure.
the Act. And you know, what contributory infringement is, what secondary infringement is, and what direct infringement is. I think those parts probably should be reassessed in light of these sites. Now, whether you can do that without having a huge fight in Congress, who knows? Probably not.
Yeah, there's no way you can avoid that, but it seems to me what you're talking about is things like MySpace saying you can host videos on your site and maybe even get revenues out of them, but trying to figure out if somebody puts something up there that's a copyright violation.
Right.
And you know, MySpace has 110 million pages or whatever it is. They may get to that page this week and find out that it's up there illegally or not. I mean, that's the sort of thing you're talking about. Who's on the hook there? Is it the
That's right.
member or is it
I think the
MySpace?
content owners are supposed to go out and look at these 110 million pages and say, oh no, these 10,000 are infringing, you have to take it down.
Right. I mean, you had the 30,000 Japanese videos that were just taken off of YouTube, for instance.
Right.
And who's on the hook and all that? That's a big question. There's no way that's not going to get into a nasty fight in Congress.
That's right. I'm not sure you can't deal with it under the current structure of the statute, but it certainly wasn't written with this type of site
Right.
provision.
Yeah, it's amazing how much it's changed since the ECA was passed.
But a good law is supposed to apply to things that you didn't think of when,
Right.
and I think it's a good law,
Yeah.
necessarily, because there's been so much lobbying to get it enacted.
Sure. And
That it's really convoluted.
It was definitely
Anybody who deals with it knows.
Yeah, right. It's that old line about elephant looks like it was built by a bunch of blind men.
That's exactly right.
We've got a few minutes for questions, so we have a lovely studio audience here. Does anybody, I know you had something, why don't you go ahead? Speak up, tell us who you are, and stand up and bellow it out.
My name is Iran from Startup. The mobile industry has succeeded to monetize content. Now, with third generation coming in, third generation mobile, are they due like the internet, or are they going to put the models to the internet?
Are you saying are they going to follow what the internet is doing?
You say with the 3G networks that the mobile guys are bringing online, the EVDO and Edge networks and the data they're shoving around, are they going to be more like an internet situation or more like a traditional, still more like the traditional mobile where they've got a 75 cents or $3 or whatever it is for every piece of content that comes over? Is that what you're asking?
Yeah.
Okay. Anybody want to take a shot at that? I mean, are the new data networks going to force the mobile guys to be more like the internet?
I think the telephone operators, the mobile operators, have got somewhat of an advantage in being able to hold on to a business model and actually impose a business model, because they have a device that has a foundation of trust. It basically is attached to a particular individual and is billable. And the end.
So the billable foundation of trust, I just want to be clear on this term, is a new one to me.
Right, the foundation of trust. Foundation of trust is a term in security where you try and find some identifier, some collection of data that identifies the person you're talking to at the other end, so you can engage in a secure transaction with the foundation of trust. There is that in your cell phone.
No, but if you can download any content, the ringtone does not have to come from the operator anymore.
Right.
Okay, I can steal it from the internet.
And
Okay,
then,
the operator loses the revenue.
and play it on your cell phone.
Yeah.
So use your cell phone maybe like an iPod. So you've got some content at home, your CD.
Well, now you can do some of that already.
You can do
The
that.
operator is losing the ringtone
Oh, yeah.
revenue.
Yeah. Well, I mean, you can already do, it's already, you go in the Apple store and you can pick up a $30 program that makes ringtones out of all those songs that you bought from iTunes.
Does that mean that the mobile industry is going to lose that content?
It's in fact it's inevitable. It's inevitable if they're making an open device. It's the same argument that's going on in France, where they're saying, here's a device that people have bought, but they want to play other content on it. You allow people to do that.
So they will lose the SMS revenues because of IM, and they're going to lose the ringtone revenues because of open platforms.
Can I just make a point here? Of course, the carriers, they're trying to maximize their revenue. So when you sign their agreements, when you read the 5-page agreements that nobody's read actually.
You read that,
It's
right?
written that, it's written that you can use only music, only download by their device. Okay. What happened 20 years ago, we had the same problem with the phone company. When you want to have a long distance call, you have to go through AT&T, and you can have another service provider. Then what happened? The market adjusted itself. So there was a phone carrier that started to change the policy and allow their customer to have external.
But to be clear, the phone company did not make that decision. A judge
Well,
did.
probably was not.
Carol Greenblatt, I think was his name, who did it at the point of his pen, said that you're going to break up and split that up. But I mean, I guess the interesting question is, how do the phone companies who have managed to cling to their monopolies, to their revenue streams for content, deal with some of the new ways to get content into machines? I mean, one of the questions is, what phone are they going to sell to run on their system, and will that phone or that set of phones be open? As you say, it's an open phone, and there's no way to control the content. And obviously, the stuff can come streaming in. I'm thinking that the least talented, most benighted phone company executive in the world would say, now why would we allow a phone to work on our system that rips up all our revenue streams? And I'm sort of curious, are you even seeing them do that?
Well,
I mean, customers might want that, but I don't think they want that. It's their network.
Revenue streams are fleeting. They don't necessarily represent long-term business that will survive. In the early days of the automobile industry, very early days, each engine was so different. The automobile companies actually sold you the gasoline, and they could have seen that gasoline sale because it was a specific mix for a specific type of car. They could have seen that as a legitimate revenue stream, but ultimately, the consumer said, no, I want to be able to buy my gas from any gas station. So that part of the business is basically, it's not there long term.
Along with 500 automobile companies.
Exactly.
So we're seeing how there's a different model in Europe. Of course, they have the open phone concept and a SIM card.
Right.
So then you're not tied to a specific network operator, wireless carrier for that particular device.
Well, I don't think that it's necessarily been a good approach for the phone companies in this country. Because clearly we've lagged in terms of services available compared to both Asia and Europe and the phone services in many, many ways. But if you're singular and you just spent, I don't know, $100 billion or whatever, figure out your number, whatever it was, to put in your 3G networks, and you haven't come close to monetizing, the last thing you want to do is say, okay, now we're going to blow out some of our streams of revenue. So I'm just sort of curious about.
And they've had to accept the fact that a certain amount of cannibalism will take place, because look at the SMS text market, where that was huge, certainly in the European market 8-10 years ago. But then along came multimedia messaging.
Right.
And so there's a dilemma. Are we going to cannibalize our lucrative SMS text to offer this new service? And of course, that would, in many instances, cannibalize their voice traffic.
Right.
So they have to get comfortable that some of this will happen.
Right. But he's right. That things like IMs will kind of take away that, particularly if you have all-you-can-eat data plans, for instance. I mean, all of a sudden, you don't send an SMS when you can just stay on AIM, talk to the folks that aren't they're online, but they're not on their phones or whatever, and go from there.
I think the ones that would be most successful will be the ones that understand that this device is perhaps the most personalized device that people will carry, because we have we have a phone in our home, and when someone dials that number, it's to anyone in the house. But with this particular device here, it really has no relevance to even my wife, because it has all of my personal contacts on it. When it rings,
She
it calls.
may find it very
Let's hope
helpful.
so, you might know something I don't.
Yeah.
But, you know, when the phone rings, it's inevitably for me, it's not for her. So everything about this is extremely personalized to my requirements. And I think the operators that understand that and exploit that will probably be most successful.
Sorry, just briefly about the IM and the text messaging. You know, they have their purposes. Sometimes I want an IM, sometimes I want a text message. You know, if I want to send a message, I want to fire and forget. I want to send the message, but I really don't want to interact with that person.
It's an asynchronous versus synchronous.
Exactly,
communication.
because I actually don't want their response right away. I don't want to have an assertion that I make challenged or
Or you don't want to have them online.
exactly. I don't want to have them online. So
Send a letter.
could send them a letter. You could send them a
You're
telegram.
so old school. You.
Yeah, Matt O'Malley with Energy. They say that, a comment, and then to add to this mobile situation, they say that 50% of content right now is off of net right now with carriers. With Wi-Fi, it's going to get much worse, and then you add in ad hoc networks where you can go person to person, no network involved. I don't know how you're ever going to track that. And Motorola is already developing a phone where it splits the processor, and it's part carrier, part independent, so I don't know how you're going to track any of that.
He can't wait.
You familiar with this new chip that Motorola developed?
No.
Okay, well,
Is that for the radio, the iRadio?
only part of it, it's only part of it is run by the carrier, the other part is completely open to the user, and there won't be any way to track it.
That's so cool.
Well, that's so much of the small wireless networks that are easily popping up other neighborhoods or areas that, yes, that's going to be a terrific challenge, obviously.
So just ad hoc lands
Yeah.
kind of thing? Okay.
Yeah.
Or land.
Like, one apartment building could have its own,
Right.
wireless.
Because you love the
That is
neighbors
how
so
back
much,
and forth, you
yeah.
can't really access it well, so.
Makes sense. In the back there?
Yes, my name is Rupert Perry. I'm going back to what you were saying about DCMA, which is kind of a local law that just kind of affects the United States in this world, which is totally global. Do you believe that these discussions about the future of copyright laws that should exist in the world today should be at a WTO level? And are any of you lobbying the WTO?
Well, I'm not a lobbyist, certainly, but the basic principles in the DMCA and the copyright law here in the United States do exist in the copyright laws of Europe and other and the Commonwealth countries, certainly. And whether they're going and they are spreading to other countries as well. I mean, I think the fundamental principles are going to continue to exist. Where you get the big fights that we alluded to earlier in this conversation, I think, are fair use and the whole notion of circumvention and interoperability, whether you can mandate that devices be interoperable, whether you can, prevent content owners from protecting their content in certain ways. That's, I think, where you're going to be getting a lot of fighting. The basic fundamental principles behind the laws, I don't see as being all that different at this point. And the WIPO treaties that have existed do try to have uniform application to all of its members, to all their member states.
WIPO's kind of in limbo right now, isn't it? Didn't the last round fall down or something like that, it fall apart?
Perhaps. So I'm talking about the existing,
Okay.
the existing
Where-
ones that are in place right now. And if they fall apart, oftentimes over issues like this.
Or local content requirements or some of that kind of stuff.
Right.
Yeah, I think what Rupert is also pointing out is that we're developing laws here that need to be enforced on foreign territory. And how to
Increase
do
that, yeah.
And we certainly, in many cases, have no jurisdiction there. And a lot of times where piracy is most rampant is in countries where piracy is the least of their concerns. They have a lot of other issues they need to deal with, so it's very difficult to actually, to enforce that.
Well, I mean, and certainly we have a challenge if you're an American content creator, because American content goes all over the world, And you can't say that about most other countries. I mean, Jack Valenti used to say, the MPAA longtime head used to say that the film business was the only American industry that had a trade surplus with every country in the world. And that speaks to a fundamental challenge when you're creating laws that affect how it's consumed here, but is also consumed by a global audience. And I think certainly as we move forward, that would be very interesting. One last, he had a question first right here in the front.
Yeah, it just continues on the legal aspects of the international rights. For example, all of MP3, why haven't they pulled that lawsuit to the States? Why is it still functioning? How did they get a legit license from the wrongs?
I'm sorry, mp3.com?
All of MP3.
Oh, all of
The
MP3.
Russian,
Oh, the Russian.
illegal site. And now, in theory, they have this legit avenue advertising revenue model. Is that real? There's a lot of smoke.
Well, they got to have legit advertising revenue, but they haven't got a license to have any of that, all of MP3, if you don't know, is a Russian site that has zillions and zillions of songs, and has said that they had acquired rights that allowed them to do that, and it has been one giant horror show, I think. Is that a fair legal assessment?
See, that's actually proving Rupert's point. That's the thing, when you have these services based in other countries that either don't follow the same rules or will not cooperate in enforcing the rules, won't cooperate with, government efforts outside the legal system to try to enforce that kind of thing, then you have this kind of thing happening, and, you probably are pretty powerless unless you can get the state, the host government to actually do something about it, which, as we've seen.
It's quite a challenge. I mean, I'll tell you what.
That's my point about
Right.
Russia wants to become a member of the WTO.
Right.
Okay? And supposedly that's about to happen because the US is apparently okay now with what the Russian government is going to do in relation to copyright.
Right.
My experience is that geopolitics is a level somewhat higher than copyright law.
Yeah. I mean, there've been a lot of nice talking, but with China as well on copyright enforcement, they've done a little bit more. But I mean, I'll tell you that when I was at MGM, one of the issues that we heard about from our pals at the trade group was, for instance, the Russian police would go in and do a raid on one of these replication lines in, fast, I mean, huge factory, essentially, popping out DVDs and CDs, and I'm sure you've heard about all this at MSK, popping out millions of copies of this stuff and sending them all over the world in ways that Afghan heroin dealers and Colombian cocaine dealers could only envy. They knew where these guys were in St. Petersburg or Moscow. They would even raid these guys, and then political things would get pulled, and mysteriously they would not only be kicked free, but so would all their equipment. And no prosecution would happen, and they would go on about their business. They had laws in the books, and it didn't really matter. And I mean, I don't know how you deal with that unless,
You deal with it at a state level, you can't do it at commercial legal.
That's beyond the power.
Our firm and the MPA, our firm shut down Pirate Bay in Sweden
Right,
for a
right.
week. The prosecutor went and shut it down, it came back as a mirror site, and now the prosecutor's like, I don't know what to do, so.
Right. Yeah, and they were mocking you guys. I remember the stuff that they were putting on the
Right.
sites and all that stuff. Pirate Bay was one of the big BitTorrent sites. Wow,
Yes, Al Perry, Paramount. Just following from that,
good to see you, huh?
good seeing you.
Yeah.
Looks like the Danish court yesterday ordered an ISP to block access to all of mp3.com. Well, that's good news.
Well, that works for Denmark.
That's good.
The vast record listening public in Denmark, thanks.
The idea, though, is that we're going to try to use that to get other states,
Right.
starting off with Scandinavia, to also rule that way. And it also helps to go to other ISPs saying, look, a court has said that you should block access to a site such as all three, and then try to get them to come to the bargaining table. So it's not a lot, but it is something.
It is a small study. It seems to be an interesting issue, though, because with the Spam House case, I don't know if you guys have been following this at all. ICANN, the registry for all the internet domain names and IP addresses, got pulled into a case where Spamhaus was an anti-spam project, a nonprofit anti-spam project in England, I think. And they got sued by an American spammer in U.S. court, and the Spamhaus guys did not contest the thing. It's a $12 million judgment. A U.S. judge initially was going to require ICANN to force them to take Spamhaus off of the registry. And it opened up really big issues, that some of which, you know, your case sort of suggests. You know, can an individual country's courts require somebody to be blocked off this international thing, the internet? And I don't think that we have a very good answer. Thank God the U.S. judge backed off on that part of his order, but I mean, I don't know that we have any more opportunities on piracy issues to require something like all of MP3 to be blocked off the internet. Certainly the Denmark court is august, but not necessarily wide-ranging. Anybody else have questions? Do you have another one?
Yeah, I have another current event question regarding LimeWire. They countersued, and I'm wondering if they have any grounds, or are they just whining?
They're whining.
Yeah?
You're,
No. I can't remember the countersuit as far as your typical copyright misuse countersuit, or is it something else?
I think it was, they were one of the five that was
Yeah.
sued in, after Grokster,
Yeah.
that they dropped the bomb.
Yeah, they were sued late, yeah, after the Spoon.
So the facts were actually, they were claiming that someone at the RIA, who was at the RIA, is now at a rival of LimeWire.
Oh, yeah.
Somehow, that.
Spiral
There's
Pro.
spiral. Yeah.
The EMI,
Oh,
full CEO.
There's a twist on the old.
that's,
It's like annex.
yeah, I figured that they also, that's their standard counterclaim now, whenever you put it in a suit, and you're a record company.
Right. I think we are done. We'll stop 1 minute early, and I thank everybody. KPMG, by the way, has thoughtfully provided a little white paper on content security, digital distribution, motion picture, music and publishing industries. It's sprinkled around here. Grab one, enlighten yourself, and thank you all for coming. Thank our panelists.